Northwestern law professor Paul Gowder joins me now live to talk about this decision that involves the 14th Amendment of the Constitution and birthright citizenship, something, again, that the Trump administration tried to strike down by executive order. Thank you so much for joining me this morning. We really, really appreciate it.
It's a pleasure to be here.
Okay, so bottom line it for us, if you could, please. What exactly does this ruling mean?
It really means that the 14th Amendment says what it says. You know, the Chief Justice, writing for a majority of the court, held that when they used the word jurisdiction in the 14th Amendment to describe the people who acquired citizenship by being born here, they meant jurisdiction, and that excluded a very small, historically narrow group of people, primarily foreign diplomats and Native Americans. Everybody else, children of undocumented immigrants, children of people on student visas, whatever, who is born in the United States is a citizen guaranteed by the Constitution from the moment of their birth.
So despite the status, the immigration status of their parents, did it surprise you, given how clear the 14th Amendment is worded, that the justices broke 6-3 in this case?
It really did. And in reality, it's more like 5-4, because while Justice Kavanaugh concurred with the decision, he would have ruled on statutory grounds because Congress had also restated those requirements in statute. So it was really only 5 votes for what to me seems like an obvious and easy constitutional ruling, which is frankly shocking and disappointing.
So let's talk about that constitutional ruling. A lot of analysts said, and I'm sure you'll agree with this, that that means the Constitution, it can't be changed moving forward. Even so, the president is now calling on Congress to pass a law banning birthright citizenship, an idea that Justice Kavanaugh gave some oxygen to in his dissenting opinion yesterday. Speaker Mike Johnson saying they'll certainly look into that. My understanding is it would require a constitutional convention. So the question being, can Congress change the law to change this ruling?
No, Congress can propose an amendment, and the amendment, if it's ratified by a supermajority of the states, can change the ruling, but Congress cannot change it by ordinary legislation.
Do you think that they might actually try to have a constitutional convention? I mean, that is a big, big undertaking.
Well, so there's a difference. There are 2 ways to amend the Constitution. There's a constitutional convention where, you know, as was said, you just create basically a convention of delegates to propose rewrites to the whole thing. Or there are constitutional amendments on a one-by-one basis where Congress can enact a proposed amendment, and then it goes to the states. And if a supermajority of the states ratify it, then it becomes part of the Constitution.
So the likelihood, I would
is more likely, but very unlikely still.
All right, Professor Paul Gowder, thank you so much.